Hi, I'm Bonnie Roy. I have been involved in the court system since 2007, with my case being assigned to Judge Philip Canning. My first attorney, Bill Moffins, had to be dismissed because he hadn't accomplished anything for me for over a year and a half. I later found a canceled check that my ex-husband had paid for him to mishandle my case. I later found another attorney by the name of Lynette Bledsaw. I believe that she would stand up for what is right because she practiced in collaborative law. I basically was on the witness stand for 3 days just in respect to this divorce. My attorney was totally silenced by the judge, who threatened her not to open her mouth during the courtroom proceeding. That attorney ended up canceling her bill of $34,000 because of my desperate situation and my inability to pay for her services. In an affidavit that she stated, and I quote, I was able to address the really outstandingly bad decisions that Judge Canning made. During those proceedings, when I asked for a $500 down payment for a deposit for an apartment or a townhome for me and my children to live, Judge Canning denied my request and left me and my children homeless, while my ex-husband remained in the marital home valued at over $500,000. Also, during the temporary order, my ex was ordered to continue paying for my health insurance. When the decree was published, this was a provision that was supposed to be removed, and I was left without insurance with no warning that this would occur. I was forced to apply for medical assistance through the county for me and my children, since my ex did not give any information about the insurance that he had provided for them. All this left me in a very desperate situation. I am a breast cancer survivor with extensive medical history, totaling over 23 surgeries and medical procedures, accumulating in a tram flap reconstruction surgery which left me disabled, and it was ruled so by the Social Security Disability Administration. My cancer returned in the summer of 2011, requiring further treatment. Ongoing care was needed, and I was rehospitalized for pain management and the lifelong physical therapy, including treatments for spinal and muscular complications secondary to the 1997 tram flap procedure. My ex-husband's attorney, and I quote, said that I had a clean bill of health. Despite 44 pages of medical documentations from facilities such as Sister Kenny, the Courage Center, Judge Canning ignored all of this evidence and out of my well-documented medical history, and he stated in court, and I quote, and furthermore, Ms. Roy, I still think you can work. He consistently ruled against me from any relief for me and my children. Being without an attorney and knowing that I had to get relief for my continued situation, I completed subpoena forms from the court and served them with my friend Linda Senst. I was seeking an alteration in child support and spousal maintenance based on my substantial change of circumstances. My ex-husband's true income had not been revealed despite numerous attempts at discovery and the use of subpoenas that were not honored. At every attempt, I turned back, but I finally found another attorney. Her name was Beth Barbosa, in whom I had to borrow money again for another retainer fee of $3,000. She was given a list of subpoenas to serve, 9 of them, along with a very clear instruction that Judge Canning could clearly not preside over my case. Ms. Barbosa served 2 subpoenas and did a late request for a change of judge. So Judge Canning, sadly to say, was presiding again over my case. I had filed a complaint with the Minnesota Board of Judicial Standards about this previous disregard for the facts, and noticed that all the things that he disregarded according to a state statute 518.17 when calculating child support and spousal maintenance. He made obviously biased decisions against me without regarding my complicated health condition and totally ignored the welfare of me and my children. I requested from Chief Justice Edward Lynch of the 1st Judicial District that another judge should be reappointed, but he refused, even though Judge Canning was completely aware that I had filed this complaint against him. I was also unnecessarily scheduled by my ex-husband's attorney, Dennis Grand, for a deposition, and they had actually presented themselves to come into my home. I then found a neutral location and was questioned for nearly 2 hours again by Dennis Grand while my daughter and friend waited in the lobby. The testimony has never been presented by the court by Mr. Dennis Grand. After Beth Barbosa withdrew the day of my deposition with no explanation, I was left again to represent myself. In a letter from Judge Canning dated September 26th of 2011, he stated that he scheduled a hearing for further argument on October 19th at 8:30 a.m. Shortly after receiving the letter, Judge Canning's assistant called me and requested possible court dates, possibly looking into November. I then received a phone call at 4:30 p.m. on Monday, October 18th, stating that the court date would remain for 8:30 a.m. the next day and threatened me with contempt of court if I did not appear. Despite the facts that Mr. Roy's tax returns showed income of roughly $90,000 in 2009, and this was also consistent with previous tax statements ongoing as far back as 5 years, and again, an average income of anywhere from $90,000 to $100,000 per year. His attorney again claimed that his income was roughly $36,000, and this is what the payments were based on. His attorney further asserted in court in October that Mr. Roy's income had not changed in the past 2 years, and yet his tax returns noted the income around the $100,000 range. Judge Canning ignored these facts and stated to me on April 19th of 2012 regarding the figures chosen for spousal maintenance and support, and I quote, this quote came directly from the judge, "It's my decision and you just have to live with it." Additionally, according to the court transcript from April 19th, page 25, beginning at line 13, it stated, and I asked this question in court, calculating child support on Rule 518.17, it states that it's calculated upon the gross income of the person paying that support. And I'm questioning how you calculated this, because if it's on the base income of the supporter, and Judge Canning basically interrupted me again, and I quote, I told you at this time I'm not going to look at it again, okay? I never received most of my personal property from the marital home, including a hope chest from my deceased father. Repeated requests were denied by Judge Canning. It was stated in the decree that the contents of the home were equally divided, but this never happened. I received no marital property, not even the beds for me and my children to sleep on. We had to use air mattresses and sleep on them for over a year. I lived in below poverty level for most of the 5 years after this divorce, and it has devastated the emotional and the physical well-being of me and my children. When I asked again about the hope chest in April to Judge Canning, he basically said that this is what I made and my decision stands. I received a letter also from him forbidding me to contact him or his staff except by mail. The staff in the courthouse treated me with totally disrespect, and I have witnesses that testify to this. He also threw out my previous motions made by Beth Barbosa, causing me to totally start over in the legal process without representation once again. When I appeared in court, Judge Canning showed total disregard for the facts presented to him and treated me with condescending in a very demeaning manner. One of my main requests was also for sole legal custody of my daughter. This was necessary because my ex-husband refused to communicate or work together in regards to medical, dental, educational decisions, and he has created much turmoil and distress for both me and my daughter. I had provided to the court and the guardian ad litem with over 150 very detailed emails and my attempts to work out these concerns. The conversation with the guardian ad litem was recorded and shows that she falsified the statements on her report and totally ignored my request for sole legal custody. And once again, these documents were presented to the court and they were also ignored. I also have the extensive email documentations with the guardian showing my concerns for her and the lack of understanding and the badgering of my daughter, which forced her into tears when she could not get the answers that she wanted from her. In court, Judge Canning also told me that I had called his office stating that I had rescinded my request for full custody of my daughter. I was shocked at this remark. I questioned the judge why would I have made a call like that, since one of my main arguments with returning to court was the request for full custody. He called me a liar in the courtroom. I never made that call. When I requested the documentation of the phone call that he claimed that I made to his office, he wrote it back in a letter, and I quote, "I did not save this message, nor do I recall the specific details of your message. I wondered again why I needed to record with the result with all my previous motions, and once again they were stricken from the court." He had no qualms about calling me a liar, yet he did not keep any documentation of a suspicious phone calls out of any other of his statements made. Most recently, Judge Canning opened the proceedings again with a statement that he quashed all of my subpoenas because they were blank, but he also noted that the requested information was unduly burdensome on certain individuals. If they were blank, just how could they be burdensome? Later, through an examination, I showed that 6 subpoenas were quashed, and I have copies of them from the court that shows the staple marks indicating that the subpoenas were tampered with. My copies that I saved at home had all the pages attached as they were delivered by the law enforcement. As a result, I was able to attain the information that I was unable to attain the information needed to once again prove my ex-husband's income, and furthermore, the subpoenas were once again ignored. Dennis Grand has not provided Mr. Roy's income and information as requested since April. Judge Canning once again gave him another extension for July 20th of 2012. This delay again put me in a very bad position. I am unable to pay my bills, I get late fees added, and I fall deeper in debt with no end in sight. I had requested that my child support and spousal maintenance arrive on time, as according to the judgment decree, for the 1st and the 15th of each month. To this date, I very rarely receive the payments on time. This makes it impossible for me to keep up with my bills and feed my children and myself. We live on $123 of food support from the county for each month. Due to the history of these late payments, I requested the full amount to be received by the 1st of each month so that I could at least make my mortgage payment. That request was also denied by Judge Canning. Judge Canning and Judge Perkins limited my informal profits, even though this was in effect. I am representing myself pro se and need legal assistance that the court is partially withholding. When I tried to deliver my last set of subpoenas, I had to borrow $140, which I was going to use for food and gas. But since Judge Canning informed Hennepin County that he was denying my informal profits, I would then have to pay for the subpoenas right there on the spot. The subpoenas cost me an additional $150. Later, Judge Canning quashed those same subpoenas and refused to consider a refund for the wasted funds. Judge Perkins limited my recent transcripts under the informal profits and recently demanded that any further subpoenas had to be approved by the court. I requested that the court honor the subpoena so that I could simply receive the necessary information pertinent to my case and end this nightmare. All these requests were once again denied. As a result of Judge Canning's actions, I have systemically brought to financial ruin. There was foreclosure of my home, repossession of my car, and a totally liquidation of my children's bank accounts, and these are only the beginning of some of the consequences that resulted from Judge Canning's ruling. I obtain food from the food shelf, have been using a friend's car, and I rely on others to remain so that I can remain in my home and pay for my utility bills. We have had our electricity shut off. Our water bill has also been extended and often has been disconnected. I continually had the marital debt and ongoing debt for me and my children, and is roughly at about $65,000. In the last year, we had visited the state representatives at the state capitol, and I have a letter from Julianne Ortman, and I quote, "It had been presented to the Chief Justice Galdey, and I quote, a comprehensive and systemic review of the family court proceedings in the 1st Judicial District, and it needs to be done specifically in Carver County. The examples and the controversies now being brought to the attention of members of the legislatures have now cast an injustice over our court system." In a personal meeting with Julianne Ortman, she suggested that I seek other ways in order to change the venue in response to the horrific challenges of the Carver County court system. We have also visited personally with approximately 40 legislators over the past year to bring this concern to their attention for the much-needed judicial reform. We have testified before the Minnesota House Judicial Committee and will continue to promote legislative changes that correct these injustices and make the judges finally accountable for their actions. They must rule according to the law and not abuse their judicial power, because the results of their rulings are devastating the lives of families all over Minnesota and across this nation.